Oh, yes, absolutely. Ashutosh, what's your take on this ongoing debate? Because
See,
whatever said and done, whatever we've learned of that 24-page suicide note, the audio that's also doing the rounds, it's touched many
yes,
hearts, right? When you
yes,
read on part of that suicide note that yeah, the victim in this case or the deceased in this
yes,
case says that
see,
if at all I win the system, then devote my ashes in Ganga, else,
yes,
else just submerge them outside the gutter of the court.
yes.
So that's
It
really
is.
hit
Yes,
everybody, and that's
yes,
why we're
yes,
talking
yes.
about this. What's your take overall?
Definitely, it is very disheartening to see, that some of the people, men are, are now made to commit suicide. This is really disheartening, and it is a very serious issue. Now, what can we say when the Supreme Court, the apex court of this country itself, has admitted in their own judgment yesterday when Telangana High Court refused to quash a petition filed by the husband and his family for quashing a 498A case, which was quashed by the Supreme Court with certain findings and observations that 498A, now Section 85, is being misused in many of the cases, and there is clear abuse of process of law by some of the women and their family members. Now, see, when these kind of cases are being filed, it is not being filed only against the husband,
Yeah.
but also against his sister, his mother. So here again, if you see, the women are also sufferers in a way. So I think the misuse of such kind of provisions have to be stopped immediately. That has to be
But
seen
how
by
do
the
you do that?
judges.
How do you
See,
differentiate
by
the right from wrong?
I come to
There's a
that.
thin
See,
line
if
here,
you
and the
see,
problem is
yes, yes,
only, else it would have
I
happened
come.
already, right?
Yes, I come to that. See, in 2014, when Arnesh Kumar judgment came up, Arnesh Kumar versus State of Bihar, which was decided by the Supreme Court, the court said that the police cannot arrest the husband or his relatives just merely on the complaint filed by the wife or her relatives in the FIR. Because before 2014, if any such complaint was filed, the husband and his relatives were supposed to be arrested by the police. And this was happening in this country. So the Supreme Court took the cognizance and said, no, first you send a Section 41A notice. You first investigate the matter and you find out whether there is really a prima facie case against the husband or his relatives or not. And then only you can use such kind of a power. And, only after that, the cases of such unlawful arrest, got stopped. Now the courts are there. So my contention here is that whenever there is any order passed by the court for issue process under Section 498A, or even the police is registering any such kind of FIR, now Section 85, I can say. So in those cases, they must see the prima facie evidences. They,
So
simply
you're
by
saying,
making
citing
stories,
these past
simply,
precedents of
yes,
the
I tell
court,
you,
the victim in this case, if it's a man, if it's a
yes.
husband in the family, can approach the court while citing these cases as precedent. Is that what you're
No,
trying to
no,
highlight?
no. I am saying that many a time, suppose if the FIR is not being registered by the police, the wife goes to the court and files a case for the registration of FIR, to get directions from the court to the police to register such FIR. So in those cases, the court must look after, the crucial evidences being annexed, whether there is really prima facie case made by the wife or her relatives or not. Because now I tell you, now the things have gone far high. Now I have examples, I have live examples where even the divorce has taken place, the alimony has been paid, the settlement has taken place, it has
But
been
many have also
complied by
called
the
for a
husband. And
need for
I'm coming
systematic
to that.
overturn
Give
in
me,
family courts, that these courts are
yeah,
overburdened. So the
yes,
wheels of
yeah,
justice
no,
are
no.
spinning real
See,
slow.
if the
That's
courts,
another
no, if the
contention.
courts, see, if the courts are overburdened, how come the courts are passing orders when there is a clear case of divorce already granted? The settlement has already taken place. The alimony has been paid by the husband. Even in those cases, the courts are summoning the husband, ex-husband, and their relative and his relatives. This is what is happening. And such ex-husband and their relatives are bound to go to the High Court to get some sort of a stay. So the question is, when the courts are overburdened, how these kind of cases are being entertained? There is a prima facie, evidences being filed by the husband. See, I have got the decree which has been passed by so and so family court. I have paid the alimony which was decided mutually by me and my ex-wife. Everything has been paid. Now the wife is making allegation, ex-wife is making allegation. I was called by the husband to stay back in the house. And here what is happening? The husband has given house, additional house to stay just to support the wife without having any obligation. And even such obligations are being treated in such a way the courts are entertaining. So my contention here is that all the courts must understand the view and the observation made by the apex court, that is the Supreme Court. When the Supreme Court is saying that, please, be careful in these kind of cases, the courts must look after these cases very, very seriously. Because see, one case being filed
why,
at the family
again,
court,
Ashutosh, it's important to get back to the drawing board and understand and tell our viewers why we're having this conversation today. One is, of course, the key observations made by the Supreme Court. The other